Now, let's say that the landlord does get approved, and let's say that the tenant owes them $10,000 in back due rent. Do they pay the entire $10,000, or is there a certain percentage that they?
Good
Uh,
question. The state would pay 80% of the
uh-huh.
rent that is owed.
Hi, everybody. This is Luiz Morales. Welcome back to the Morales Group Show. This is episode number 59. Today we've got Anthony. He's a local attorney here in Southern California. And today he's going to be educating us today on some of the landlord assistance programs that are out there for landlords that aren't receiving rents from their tenants. So this is definitely an episode that you do not want to miss. Before we get into it, I want to ask you guys, if you haven't subscribed, please hit the subscribe button, hit the like button, and hit the share button. Welcome to the show, Anthony. How are you?
I'm doing good. Thank you for having me.
Yeah. So essentially, there are some landlords out there that, unfortunately, because of the pandemic, are in a position where their tenants are not paying rent. Some of them have tenants for 3 months, 6 months, 12 months, even longer than that. I hear that there's a program out there that benefits landlords and that allows them to recoup some of that unpaid rent. Can you tell us about that program? What is the name? How does it work? And what are some of the insights that you can share about it?
Great. So there's a few programs out there for California landlords. I'm
Uh-huh.
going to particularly pay close attention to the state one and probably the one for the city of Los Angeles.
Uh-huh.
It was federal. It's basically federal funding that allowed the state of California to provide renters assistance.
Uh-huh.
The little difference between this program and some of the ones that started in the beginning of the pandemic
Uh-huh.
are that these programs a landlord can actually apply with it, but a landlord will need the tenant's assistance in
Uh-huh.
order for some of the documentation about the tenant. One is from the state of California, which is accessible on a website at housing.ca.gov.
Mm-hmm.
And the second is through the city of Los Angeles for landlords within the city of LA.
Mm-hmm.
That is through the housing department, hcidla.lacity.org.
Okay. And are these two different programs, or are they the same program, just the application process is different?
These are the same programs. So, for example, if you're a landlord in the city of LA and in certain other areas, you aren't able to qualify under the state program. You would actually have to qualify under the local program.
Perfect. Okay. And then I know that Ventura County has a program like that as well, too, or so I read. Do they have a website as well, too, or?
What? Ventura County, I believe, let me confirm with you. Ventura County actually is within the state program. So that one you could actually go to the statewide website, and a Ventura County landlord could apply under that program.
Fantastic. Okay, good. And then what does the application process look like? Like, I know that you said that a landlord could actually apply, but they may need some of the tenant's assistance. What does that process look like, and how would the landlord need the tenant's assistance, or in what way?
Sure. So there's a few documents you're going to need as the landlord that the landlord would have. For example, you need a copy of a rental agreement. You may need to provide some sort of ledger that shows that the amount of rent that is owed. They're going to show, they want to see some sort of ownership interest. So they're probably going to need to see a deed of some type that shows that the landlord actually owns the property. Now, these programs are actually meant to really focus on low-income residents. So on the tenant side, they're going to have to show that they qualify. And under most programs, I believe the state and the city program, both of them require that the tenant fall below 80% of the average income for the area. Now, what that means is the tenant is going to have to show some sort of documentation, pay stubs, EDD money, or something like that, showing that they qualify, that they fall within those programs. So, for example, if you have a high-income tenant whose rent is $10,000 a month, that landlord may not qualify for renter's assistance.
Okay, so
And
essentially,
this program's a yes.
say it again.
This program is a little different because this will actually get paid. Landlords would actually get paid directly from the state or from the city.
Perfect. Okay. So essentially it's meant to help. So the way that it's calculated, you take a look at the median income for your area and then you multiply that by 80%. And essentially the tenant has to make less than that in order for the landlord to potentially be able to qualify for the assistance program.
Correct. It's also important to notice when you do if anyone's looking at the average income for the median income for the area, you also have to go by the number of people the tenant is reporting as living in the household. So for example, the median income would be different if you had a 4-person household or a 7-person household or a 1-person household. It's vastly different. So that makes a little bit of a difference when the landlord applies.
Okay, so it's basically based on that. Now, where could somebody go to find the median income for their area? Is there a website like that, or?
I believe it's on the housing.ca.gov.
Okay.
And my suggestion would be, even if you don't know what the tenant's income is, landlord may want to still apply, unless you're in a situation where you have a tenant that's clearly outside that realm. But because people may have faced financial hardship in 2020 and currently, they may be making lower income than they were when they applied for the apartment in 2018, for example. So it might be worth talking to the tenant and kind of seeing where they are in terms of what their income is currently.
Now, what happens if, like, for whatever reason, that relationship has been strained because of a lack of payment from the tenant? Like what if a tenant doesn't have any cooperation from their, or the landlord doesn't have any cooperation from their tenant? Is there anything that landlord in particular can do, or just apply and express to them that your tenant won't tell you how much income they make, or how would that work?
I still think it's a good idea to apply. My suggestion is if you have an email address or by text message so that it's in writing, to make sure you ask, as a landlord, to ask the tenant to provide the documents once a landlord does file that application, and perhaps even show a screenshot or a printout copy of what's required from the state or from the city or from the county to show a tenant that they have to provide that information, or they should provide that information. And it would serve both parties' interest, because there are certain protections with regards to evictions where if it's seen that a tenant or a landlord is not attempting, at least, to try to get some assistance from this program. Okay.
So essentially, can you elaborate a little bit more on that?
Sure, because my suggestion would be, because I know some tenants may be wary if a landlord just knocks on the door and says, I need your pay stubs right now.
Oh yeah.
So that's what I'm suggesting. If you can go out as a landlord, maybe provide the screenshot or the printout of what's actually required from the state of California, and to not just knock on someone's door and ask for these documents. Because I could see a tenant being very wary about that. Yeah. And when the eviction processes can start in the summertime, my concern is that if a landlord is shown that they did not at least attempt to get government assistance from these programs, that they may not be able to evict. And there's a number of laws, which we won't get into today, about the eviction process in the summertime. But one of the additional things is that the landlord and the tenant have at least attempted to reach out to these programs. Because in my mind, compared to some of the other programs, these will be somewhat well funded right now. So it's not that they're going to run out of money very quickly like some of the other programs did when the beginning of COVID occurred. I think this one might actually last for a while. So I think that as a landlord, I think although a landlord should apply sooner than later, I think there will be hopefully enough money that landlords who do need it or want it will be able to get some.
Yeah. Would you recommend that even though it could be well funded, do you recommend that they apply the sooner the better if they are looking for assistance? Because
yes, apply the sooner the better. If you can apply, I think it's always better, because I think although there have been some advertisements I've seen for it, and people are starting to mention it. I think as it becomes more common, you may see even more of it. And my concern is, of course, that there's limited funding, although I'm not saying it's unlimited. And so eventually it will run out. So it's always better to try to apply for it earlier than later.
Okay, perfect. Okay. And then I know that you mentioned that they might require some proof of ownership. Obviously, they might require some information for the tenant. Anything else that kind of stands out to you off the top of your head that they might?
No, those are the big ones. You would the rental agreement, documents regarding ownership. One second. Perhaps the property tax statement. They may need insurance information. I think more of it is leaning towards that, you're the owner of the property to avoid any sort of fraud claims.
Okay, perfect. And then once like a landlord applies to these programs, how do they keep up with it? Is there like an online portal where
there's an online? So all these programs are actually online now. So there's online portals, and there'll be email updates to all of them. Okay. And I believe the city one is email updates, and I believe the statewide one is for the most part an online portal that you could probably check and see if it's been accepted, or when payments are going to be made, and if it's been denied, or for whatever reason, what other documents are required of you.
Okay, perfect. Now let's say that the landlord does get approved, and let's say that the tenant owes them $10,000 in back due rent. Do they pay the entire $10,000, or is there a certain percentage that they?
Good question. The state would pay 80% of the rent that is owed.
Okay.
So they would pay 80%. But it's important to note that if you're a landlord and saying, well, what about the 20%? The state is asking that if you accept the 80% figure, that you would waive the 20% rent owed. But my concern is that on the landlord's end, it may sound like a better deal than it sounds like a better deal than it even is, I think, because under the statewide eviction moratorium, a tenant is only obligated to pay 25% of the rent in order to avoid eviction. And so if they pay 25% of rent owed by June 30th, they avoid an eviction, and the landlord has to turn around and then file a small claims lawsuit to get the balance of the 75%. So a landlord, in my mind, might be in a worse position by doing that, by getting the 25% and then also having to sue for the 75%, than perhaps just getting the
80%. I'm on the same boat as you. I think it sounds like more appealing, because the reality is that if you go to small claims court, getting a judgment is one thing, collecting is a completely other thing. Like being able to on any funds is a completely different animal.
Anyone who's ever gotten a judgment will understand that judgments are somewhat difficult to sometimes collect on. I'm not saying it's impossible, and it depends on every tenant situation, but generally collections can only go against a tenant's wages, bank accounts, and if they own any real property. And so those are your three big avenues of collections. So if you have a tenant that does not have any money, generally it's going to be somewhat difficult to get collections from them.
Okay. Do you know how long it's going to take for landlords to get their money? Like, let's say that I apply today. It's just like a 30-day process, a 60-day.
Since it's such a new program, I actually don't know. And I don't know from just practical experience, because it's such a new program, how long it will take for the money to actually start flowing once you do the application process, and how long the application process actually takes. Again, because such a new program, some of my clients have slowly started to get put the applications together, but I think a lot of them, just because it's only been 2 weeks, a lot of them are still kind of waiting on it.
Yeah. Now, what happens like after the fact? So let's just fast forward. It's May. I receive the 80%. I've forgiven the remaining 20%. So we're at square one. Is the tenant required to start making payments at that point? And
so state law would say that the tenant is required to start making full payments of rent on July 1st. So if you apply now, I believe that you may be able to even apply for April. Well, now is April, but for May and June's rent. But then after July 1st, a tenant is responsible to pay the entire amount of rent. And a lot of the COVID rules that we have addressing evictions are going to change again, reverting back to the 3-day notices that people are familiar with.
Yeah.
However, that's assuming that things don't get extended in June sometime.
Now, does this law have any future restrictions for landlords? Like, let's say that come July 1st, the tenant doesn't pay their rent, and let's say that the eviction moratorium doesn't get extended. Just because they accepted the money from the government, does that prohibit a eviction process in any way, shape, or form if they miss payments after July 1st, as long as that doesn't get extended or changed?
The after July 1st period is going to be an entirely new period, so I don't believe so. I think, but you cannot evict for the period before June 30th for any amounts that are owed. That's why it's important for that landlord to make sure to put all the amount of money that's owed.
Perfect. When you say it's important for them to put all the amount of money that is owed, what do you mean by that?
If a tenant owes for the entire amount since March through current, to indicate that on the application. Remember, as a landlord, and it's important to note that the state will not pay for any late fees and other types of charges other than rent. So, and you wouldn't be able to collect that anyway at this point. So it's important to note that. So it's just the rent. So it's really important to keep a good ledger. And if you do have partial payments, to indicate that on the application, you can.
Yeah. Let me ask you this, and this might be a little complicated, but I have a client who bought a property in December of last year, and the tenant has been behind on since March. Do you think that landlord would be able to collect since March, or do you think it would probably be from December, from the time that he took ownership?
So generally, right now, you can't sell COVID-19 debt, which would be the debt from March through December. So a landlord generally can only, because we're only entitled to rent starting on the date that they took ownership. You generally are not able to go after the rent for a prior landlord.
Of course. Okay.
That was owed to a prior landlord, if that makes sense.
Yeah.
So I think, so for that particular client, if you bought in December, you would most likely only be able to start say that you didn't receive rent in January.
Perfect. And then,
I was going to say, because unless they're generally you used to be able to assign the amount of money, but under the new COVID laws, you're not able to assign that money. So you would only be able to collect from the future ownership, or when you owned it, from the day you owned it.
And then if somebody sold a property already and the tenant's no longer there, could they collect? Or since they sold it already, it wouldn't be part of the program?
I actually don't think it would be part of the program, because I think it really is aimed at protecting, to keep people in their homes.
Yeah.
So at this point, it would probably not be.
Perfect. That makes sense. Okay. Now I know that you said,
but then again, I don't know off the top of my head. But you may want to check the application process. But I'm almost positive it wouldn't be.
Yeah. Now, what about utilities? Like, let's say that the landlord pays utilities for the tenant on a single family residence. Are they entitled to recoup? I know you said no late fees, but are they entitled for utilities at all, or no?
No. If a utility, let's say, for example, if a landlord is paying the water bill on a property and you have a tenant that's not paying, unfortunately, there's no way to recoup that. There are other assistance programs involving water bills. But when it comes to the rent itself, you're basically only, because that's not a bill that a landlord is passing on to the tenant. It's just a bill that the landlord has. So there are other programs, I know, with water bills, electric bills, and etc. There are programs out there that are helping people if you aren't able to pay, and I believe there's still some rule somewhere that says they're unable to cut off services right now if for non-payment. But if it's not a bill that you transfer to the tenant that the tenant's obligated to pay, this is simply for the rent. If it's a utility bill that somehow is obligated to be paid by the tenant as part of the rent package, then yes. But that would, because ultimately it's a bill that the tenant is supposed to pay. Yeah. But not if, and it would be considered rent. But if it's just the water bill, it's not. And and this is a question that comes, since you mentioned it, it's a question that comes up a lot. If you have a tenant that has not paid for a year, and even if they have not paid for a month, the landlord cannot shut off services, meaning they cannot shut off the water, cannot shut off the power or the gas, terminate landscaping or something like that, because the tenant's simply not paying you.
Yeah, that's something that some landlords think that they can do that they can turn off the utilities, but no, you can get in a lot of trouble if you do that, right?
There's a lot of liability for a landlord that does something like that. I would never suggest under any situation. It's illegal, and it's not a good idea. No. It really will make a bad problem much worse.
Absolutely. Good. Is there anything that we missed that you think would be helpful for our landlord clients?
The landlord clients, if you do have tenants that are owing a substantial amount of money at this point, particularly ones that have not paid since March, it might be starting to be a good idea to talk to your tenants about possible payment plans, or or for the applications to the government assistance programs. As I said earlier, the eviction process, if a landlord believes that they should just go evict this person on July 1st because they haven't paid the rent, there's a number of laws that protect tenants due to COVID-19, and also the length of the eviction process once landlords are able to evict at that point for these reasons, for non-payment cases, are going to be pretty long. And so I think it would serve everyone's interest to try to come up with some plans with regards to payment or some sort of move-out idea on both sides. My first suggestion when anyone calls my office is to try to talk, for a landlord and tenant, to try to talk to each other. It generally is the best way to at least start a conversation about payments. But I do know from a lot of stories that some tenants are ignoring the landlord upon multiple requests. And if that's the case, you may want to start the application process. But I would always suggest that, in writing, try to tell the tenant what kind of documents you'll need that you're being asked for by the state for the relief programs.
Perfect. Okay, sounds good. Where could people find you if they wanted to get a hold of you?
Sounds good. My office is located here in Glendale. My phone number is 818-839-5220, and my website is marinacciolaw.com. And those are the best ways to get a hold of me, and I am available for consultations.
Sounds good. So this was episode number 59 of the Morales Group. If you have any questions, you can reach out to Anthony directly. In the comment box, if you want to ask anything, you can ask it, and obviously we'll do our best to answer it. If you haven't subscribed, once again, feel free to hit that subscribe button, like it, and share it. Thanks so much, everybody. Episode number 59, Morales Group Show, landlord assistance programs for tenants that are not paying their rent. Make it a great day.
Thank you for having me.